On the 24th of March 1998, a bill for an act to revise and reform the laws relating to sexual offences was passed by the Parliament of the Commonwealth of Dominica. That was Sexual Offences Act number 1 of 1998. And now, some 11 years later, how much do persons on Dominica really know about this important piece of legislation? How familiar are we with its varied sections and provisions? In fact, what specific areas does the Sexual Offences Act number 1 of 1998 cover, and what are its various provisions? Stay with me for the next few minutes as we examine and dissect this law. Together, let us explore the provocative and almost taboo topic of sex and the law in Dominica. The sexual experience has always been with us, and we expect that this delectable fruit from the heavens will always be part of the human experience for eons to come. But as with most forms of pleasure, mankind has found, sometimes to our peril, that sex is best enjoyed in moderation and within clearly established rules and conventions. This may be one of the reasons for the implementation of legislation and regulations relating to sexual crimes and sexual violence in societies around the world. Mrs. Alex Boyd Knight, noted local legal luminary and a veteran of cases in this field, has some general thoughts on the development of sexual legislation and societal evolution.
Intellectuals over the ages have debated the question as to whether the laws are made to shape societal behavior, or whether it is that laws are enacted based on prevailing societal attitudes. A sort of a legal which came first, chicken or the eggs conundrum. I would like persons who view this documentary to reflect on that idea as I go along, particularly as we consider how much attitudes towards sex and sexuality have changed the world over, particularly during the last 50 years.
But what has been our experience over the years with this issue of sex and the law? Are sexual crimes and sexual violence a major problem in Dominica? And if so, how do local crime figures in this area compare with the prevalence rate and crime statistics from our neighboring countries, especially within the OECS? Yvonne Alexander, a veteran of the Dominica Police Force, provides some insight into this.
From a practitioner standpoint, I would say that sexual offenses in Dominica are too prevalent. Generally, we average about 90 cases per year, but that is reported cases. And we would well understand that there are many other offenses that are not reported to us that come to our notice. In relation to other Caribbean countries, I can tell you that in 2002 there was a research done by UNICEF in collaboration with the National Children's Home, and that research did reveal that Dominica's prevalence rate was much higher than that of the other OECS countries. It is worrying because a lot of the offenses, the highest prevalence in relation to our sexual offenses here in Dominica is in relation to offenses against minors, girls under the age of 16 years. So that is worrying. I mean, when you consider, you know, the type of people we are, the fact that this speaks to the very moral fabric of our society, a society that we claim to be God-fearing. So this is worrying.
The Sexual Offences Act is therefore one of the main weapons available to the general public to curb, reduce, and hopefully eliminate the scourge of sexual crime in our society. Alexander, a leading practitioner and expert on this legislation, outlines the main objectives and provisions of this important piece of legislation.
I suppose the main objective of the Act is it is a modern piece of legislation in comparison to what obtained on our statute books prior to its enactment in 1998. Its main provision is all of the wide range of offenses that it caters for. Various conduct that would result in a crime, sexual conduct that would result in a crime. Among the main provisions is, well, the range of offenses, the offenses of unlawful sexual intercourse, that is sexual intercourse with individuals referred to as minors, usually people under the age of 16 years. It makes special provision in the event the offense is committed against a child who is 14 years for a term of 25 years imprisonment, as opposed to a child who is under the age of 16 years, between 14 and 16 years, where the imprisonment term is 14 years. It also allows for, there are certain other interesting and innovative enactment in this particular law. For instance, in our previous law, there was not the provision for these matters to be heard privately, what can be referred to in the legal terms as in camera. So that particular law provides for those offenses to be heard privately. It also, another innovation is the fact that it makes provision for matters relating to sexual offenses or people being charged with those offenses not to be broadcast. So that again is another something that is new, something that is innovative as compared to what previously obtained.
A slightly different focus relating to the protection of children was obtained from Gloria Augustus, a leading local magistrate.
In terms of sexual offenses and children, there are several pieces of legislation that deal with that. The main one being the Sexual Offences Act of #1 of 1998. Also, there's the Protection Against Domestic Violence Act that deals with an aspect of that, and the Children and Young Persons Act. In the Sexual Offences Act, we see the case, it relates specifically to rape, incest, sexual connection. Also, there is intercourse with a person under the age of 14. There's intercourse with a person between the age of 14 and 16. You also have indecent assault, gross indecency, buggery, and there's also the aspect of unlawful detention of a person for sexual purposes. There's also sexual intercourse with an adopted minor, sexual intercourse with a minor employee. All these are offenses under the Sexual Offences Act. The main one that comes to the Magistrates Court is sexual offenses with a child or under the age of 14 or between the age of 14 and 16, sexual assault, sexual connection,